The polished glass doors of Wexler and Crane LLP whispered shut behind Jamal Harris as he stepped into the towering law firm's Manhattan office for the first time. He stood for a moment in the marble lobby, adjusting his slim-fit navy blazer and clutching the leather binder he'd spent the weekend perfecting. Inside were research notes, strategy drafts, and a legal theory he believed might actually impact one of the firm's biggest upcoming class action suits. At 24, Jamal had already earned a reputation at Howard Law for being meticulous, brilliant, and quietly relentless. He wasn't from privilege. No Ivy League surname or legacy recommendation had opened this door, just raw merit, sleepless nights, and a personal mission to prove that he belonged. As the firm's summer interns were led into the conference room for orientation, Jamal couldn't help but notice the subtle glances. The other interns, mostly white, a few from Stanford, Columbia, and Harvard, eyed him with a mix of curiosity and distance. No one said anything, but he felt it. Later that morning, the firm's senior partner, Gregory Wexler, called for a strategy briefing on the highly publicized Sheldon versus Vector Tech case, a class action involving thousands of workers wronged by a tech giant's privacy violations. Every intern was told to observe quietly, but Jamal had done his homework thoroughly. As the meeting went on, Wexler and the litigation team debated motions, deadlines, and precedents, circling around a defense strategy that seemed half-baked. Jamal hesitated, then raised his hand. Wexler barely glanced up. Interns observe. We'll hear from associates later. But Jamal couldn't let it go. Excuse me, sir, I just wanted to mention there's a 2009 federal ruling in Kingston versus MaxTech that involved near-identical digital consent language. The court ruled against the corporation based on consumer intent interpretation. I think we can use that to distinguish Vector Tech's argument and shift the liability model back on them. There was a beat of silence. Wexler finally looked up, not impressed but irritated. You're here to learn, not to teach. Stick to taking notes. The associates looked away awkwardly. Jamal swallowed his pride, nodded, and sat down. He didn't say another word for the rest of the meeting. Afterward, as the others left, Jamal heard laughter down the hall. One associate muttered, Howard Law trying to school Harvard attorneys. Bold. In the break room, no one made space for him at the table. He quietly poured himself coffee and went back to his desk, where he opened his binder again. The page he'd highlighted, the Kingston case, stared back at him. He closed the binder, but not the idea. The days that followed were a blur of rushed footsteps, highlighters squeaking across contracts, and the quiet sting of invisibility. Jamal Harris found himself shoved to the periphery, not through outright insult, but with a precise indifference only institutions of power could master. Other interns were invited to observe depositions, sit in on briefings, even tag along to client lunches. Jamal, however, was handed delivery orders, asked to organize case files, and told to monitor the printer queue. His attempts to join legal discussions were ignored. His email responses went unanswered. Once, when he offered a small correction on a drafted motion, a genuine error, caught only by his careful eye, he was met with a cold stare from a junior associate and the words, "Try not to overstep. This isn't your class moot court." Even so, Jamal refused to disengage. Each night, after the office dimmed and the interns filtered out, he stayed. He pored over the Sheldon vs. Vector Tech case. Quietly, methodically, he traced the paper trail of digital consent missteps made by the tech company. He connected dots between user agreements, metadata usage, and outdated privacy protocols. And at the center of it all, the Kingston vs. MaxTech precedent he'd mentioned on day one. Still unused, still unrecognized. One night after midnight, he stood alone in the glass-walled conference room. A legal pad lay open beside a stack of court records. He scribbled out what he believed could be the strongest defensive angle the firm had. He knew if they filed under standard tort, they'd lose. But if they pivoted to a digital negligence framework, backed by Kingston and 2 recent circuit opinions, the case could turn entirely. He quietly printed a copy of his memo and slid it into a manila folder labeled to Rita Flores, Associate, RE, Potential Alternate Strategy. She'd been the only attorney to smile at him. Maybe she would read it. That same morning, as the other interns filed in dressed sharp and eager, one of the senior partners passed Jamal by and dropped a paper cup into his hand. Black, no sugar. Don't forget the scones this time. Jamal nodded without reaction. He didn't need them to see him now. He just needed one person to read the folder. Rita Flores had seen it all in her 5 years at Wexler and Crane. The ambition, the posturing, and the quiet burnout of interns trying to stand out. But something about Jamal's manila folder, left respectfully at the corner of her desk, caught her attention. The label was handwritten, modest. Alternate strategy suggestion, J. Harris. Most interns wouldn't have dared. Curious, she opened it. Inside, Rita found a tight, logical argument with meticulous references and sharp observations. Jamal had identified not just a precedent, but a pattern. He laid out how Kingston versus MaxTech could create an opening for a data negligence argument against VectorTech, turning the company's terms of service language into a liability trap. He'd connected obscure but valid federal rulings and even proposed how the motion could be structured. She read it twice, then a third time, and she sat back in her chair, stunned. This was good. Not just intern good, but litigator-level good. And it wasn't just creative, it was dangerous. For VectorTech. Rita picked up the phone and dialed her supervisor. Quick question. Has anyone looked at Kingston versus MaxTech for the Sheldon case? A pause. Why? No reason, Rita replied. I'll get back to you. Later that day, while Jamal was restocking printer paper near the mailroom, Rita walked up beside him. You have 5 minutes to explain this to me, she said, holding the folder like it was evidence. In plain English. Right now. Jamal blinked, then nodded. He walked her through his logic calmly but passionately. No arrogance, just clarity. By the end of the 5 minutes, Rita's expression had changed. She wasn't just impressed. She was thinking, the way only a good attorney does when a door appears where none seem to exist. You've got something here, she said finally. I'm going to bring it up. You won't get credit, not yet. But if it lands, they'll have no choice. Jamal just nodded, keeping his face unreadable. But as she walked away for the first time since he stepped into the firm, he allowed himself the smallest smile, not because he was about to be noticed, but because the truth, finally, had a voice. The courtroom was packed. Reporters flanked the gallery. The plaintiffs, hundreds of former employees wronged by VectorTech, waited for justice. The defense table, manned by Wexler and Crane's top litigators, buzzed with tension. Jamal sat in the back, in the farthest row, notebook on his lap, invisible again. But this time, something was different. At the head of the defense table sat Rita Flores, armed not with the firm's original playbook, but with the memo Jamal had written. She had spent the weekend quietly building a new argument, integrating his digital negligence framework and the Kingston vs. MaxTech precedent. She hadn't told Wexler the full truth yet. She needed to see if it worked first. The plaintiff's attorney had just delivered a damning blow, an internal email from VectorTech admitting their data disclosures were misleading. The courtroom murmured. Rita stood. Your Honor, she began, voice steady, we move to introduce a revised theory of defense. While the plaintiff focuses on breach of consent, we argue this is not a consent issue. It is digital negligence, under the precedent established in Kingston versus MaxTech. Wexler's head whipped toward her. So did the opposing counsels. The judge adjusted his glasses. You're invoking Kingston? Yes, Your Honor, she replied, handing over printed briefs. The company's lack of protocol and failure to update digital disclosures falls squarely within the negligence standard defined in that ruling. The room went silent. The judge began flipping pages. The plaintiff's counsel tried to object, but the judge raised a hand. I'm listening. Jamal's chest pounded as he watched the courtroom absorb the very idea he'd been told to keep quiet. Minutes stretched. The judge leaned forward. Proceed. From there, the tone of the trial shifted. The plaintiff's argument, while still valid, now had to contend with a new framework that didn't excuse VectorTech, but refocused the burden in a way they hadn't prepared for. The defense suddenly had leverage. The firm wasn't just surviving. It was fighting back. Back at the office, Wexler called an emergency meeting. Rita walked in confidently and placed Jamal's memo in front of him. You should read this, she said. Wexler skimmed the first page, then looked up. Expression unreadable. Where did this come from? Rita didn't blink. The intern. For the first time, Gregory Wexler was speechless. Gregory Wexler stood in his office, hands in his pockets, staring out over the Manhattan skyline. Behind him, Jamal sat in one of the leather guest chairs. Not slouched, not defensive, just calm. His binder was in his lap, worn at the corners. Let me get this straight, Wexler finally said, turning around. That memo, the Kingston argument, it was all you? Jamal didn't flinch. Yes, sir. Wexler paced, tension sharp in his shoulders. And you gave it to Rita, not to me? Jamal's voice stayed level. I did try during the first strategy meeting. I mentioned Kingston versus MaxTech. You told me to stay quiet and take notes. Wexler's mouth opened, then closed. He remembered. He hadn't even looked up from his legal pad. Outside the glass wall, associates were whispering. Word had traveled fast. About the intern, about the court. Some were already calling it the save. Wexler rubbed his temples. Do you realize the position you've put me in? I didn't put you in any position, Jamal replied evenly. I just followed the law. It wasn't arrogance, it was truth. There was a long silence. Then, without looking up, Wexler said, The judge bought your angle. Opposing counsel requested a continuance. We've got leverage now, because of you. Jamal didn't respond. Wexler finally met his eyes. You want to be an attorney here someday? I want to practice law, Jamal said, where people listen when the law makes sense, no matter who it comes from. For a moment, Wexler said nothing. Then, with a resigned sigh, he sat down behind his desk and pushed Jamal's memo to the center. Then, we better give them something else to talk about in court. The courtroom was different this time. Jamal didn't sit in the back row. He sat directly behind the defense table, in a chair marked Legal Assistant, next to Rita Flores, the one person who had seen him first. The trial had resumed after a brief continuance, and today, Wexler himself would be presenting the argument based on Kingston versus MaxTech. But this time, he wasn't presenting Jamal's idea as his own. Your Honor, Wexler began, rising with careful poise. Today I'd like to revisit a critical element of our defense strategy. This approach, proposed and developed by one of our interns, Mr. Jamal Harris, has reshaped our understanding of this case. A murmur passed through the courtroom. Wexler continued, Mr. Harris found a legal foundation that brings VectorTech's actions into a broader context, one where their negligence becomes not just a contractual issue, but a violation of public trust. We believe the court will agree. Jamal sat frozen. For all his preparation, he hadn't expected that. When court recessed, reporters crowded outside. A few interns stood in the hallway, stunned. One of them, a guy from Yale who hadn't said a word to Jamal all summer, came over awkwardly and said, Hey, that was you? Kingston? That was your brief? Jamal just nodded. That afternoon, back at the office, an all-staff email went out from Wexler's assistant. Thanks to the work of our litigation team and the contributions of intern Jamal Harris, Wexler and Crane has secured a major breakthrough in the VectorTech case. We celebrate innovation at every level. The email lit up Jamal's inbox. Associates he'd never spoken to sent replies. Rita stopped by his desk and dropped off a business card with a handwritten note. Let me know if you need a reference next summer, or sooner. Later, as he packed up for the day, Wexler approached. He didn't smile, but his tone was softer than before. You've got the instincts. Don't waste them. Jamal gave a slight nod. Thank you, sir. Wexler looked him over once, then walked off. And for the first time since arriving at the firm, Jamal didn't feel like he was being watched. He felt seen. The ruling came down on a Thursday morning. The courtroom was tense, every seat filled with attorneys, plaintiffs, journalists, and corporate observers. When the judge entered and announced the verdict in favor of the plaintiffs, validating the digital negligence theory, citing Kingston versus MaxTech as a core precedent, the room erupted in a stunned mix of gasps and murmurs. It wasn't just a win. It was history. The class action settlement was expected to reach over $110 million, a record-setting sum, and a precedent-setting ruling that would ripple through the legal world. And at the center of it all was a theory, born not in a partner's office or a polished boardroom, but in the quiet hours of an intern's lonely after-hours research. Later that week, Wexler and Crane held a press conference. Cameras flashed. Reporters fired off questions. Gregory Wexler stood at the podium, stoic as ever, and cleared his throat. "Before we begin," he said, "this firm would like to acknowledge the critical role played by one of our summer interns. Mr. Jamal Harris's insight and research laid the foundation for our winning argument. He reminded us that innovation does not care about seniority. It only demands we listen." The camera swung to Jamal, standing off to the side in his neatly pressed shirt and worn shoes, looking like he still couldn't quite believe this was real. That afternoon, 3 law firms emailed him offers. 2 legal journals requested an interview, and Rita handed him a sealed envelope from Wexler. Inside was a full-time offer to return after graduation and a scholarship grant to cover his final year at Howard. But Jamal didn't rush to accept. Not yet, because now, for the first time, he had options. That night, as the city shimmered below his apartment window, Jamal opened his old binder, the one that still held his first draft of the Kingston theory. He flipped past the notes, past the outlines, and stopped on a blank page at the back. He picked up a pen and wrote, "They tried to silence me, so I made the law speak louder.